Good evening and welcome to In the Public Interest. I'm your host, Ryan Lilienthal. If you're listening to us, we're coming at you live on WIMG 1300 AM. If you're watching us, you're seeing us on WZBN Mercer Channel 25, and we can be found on the World Wide Web at WIMG1300.com. I am pleased to have with me tonight Liz Zuckerman, who is an employment discrimination attorney addressing inequities in the workplace with her office in Princeton. Liz is a landmark case attorney, former Deputy Attorney General with the state of New Jersey, a former president of the New Jersey chapter of the National Employment Lawyers Association, and Liz was selected by the Chief Justice of the New Jersey Supreme Court to co-chair the state's task force on gay and lesbian concerns, and I'm really happy to have you here.
Thank you, Ryan.
And we're going to be talking about these landmark cases and your role as a lawyer and why you became a lawyer.
Okay.
And so let me just start with a little bit more about your background. You grew up in New Jersey, and you became an attorney. Why the law?
Oh, well, that's not a very interesting question. It's probably in the blood. There's a lot of lawyers in my family, and I just found that was probably where my aptitude lies. But I went to law school out in California at UC Davis and found that in addition to, having it come naturally, it's very interesting work. And I particularly enjoyed it because I got to do some work on gay and lesbian issues out there and on the issue of parenting, second parent adoption for lesbian parented families, and wrote a law review article on that. And it actually became sort of the centerpiece for what has become the law here in New Jersey, which is similar to step-parent adoption, where a lesbian woman has a child, and her partner then is permitted to adopt those children and acquire rights and responsibilities for those children, while the biological parent, of course, retains her rights. So that was very interesting work for me.
The listeners should know that it's not every attorney that is cutting new pathways into the law. And you've described one way that you've done it with the law review. You've introduced language into the law, the second parent adoption.
Yeah.
And of course, we'll get into some of these other cases. But it seems that a lot of your focus is on the social action, social justice stuff.
Well, I mean, doing plaintiff's employment work is sort of like being a social worker. I mean, there's a lot of it where I am counseling people who are in times of distress. They come to me when they've lost their job or they are being harassed or discriminated at the workplace. And I try to help them. Sometimes I'm able to, sometimes I'm not, but it's real good work. And sometimes I'm able to create new law along the way, which is, there's nothing more fun than that, really trying to stretch definitions and ways in which courts are willing to think about the law.
Yeah, when you got into law, well, I'm not sure that you were thinking about being a social worker but in terms of the social action part of it, did you have in mind, this is what I want to do with my career?
I can't say that, although, I mean, when I was first looking for work, I was looking for legal work at places, that did work on behalf of the downtrodden, if you will. But in the end, I got a job as a Deputy Attorney General, which gave me an opportunity to represent state agencies, Department of Labor, Department of Health, and that was good work and got me a lot of good experience. But I didn't actually get into employment law until a little later in my career, when I really stumbled upon it. A young woman came to me, Lisa Schmidt, with a sexual harassment complaint, and I took that case on, and it ultimately went all the way up to the New Jersey Supreme Court. It really created quite a uproar in the legal field, creating new law, and that kind of built a name for myself out of that case. And from there, I've kind of never looked back. It's been employment law all the way.
I want to back up on the Schmidt case in a second.
Yeah.
But you indicate that you were a Deputy Attorney General.
Right.
I think of the Deputy Attorney General. I think of the state, and I think of law enforcement. And I don't necessarily think of representing the vulnerable.
Right.
And so what was that experience about?
Well,
And-
first of all, I was on the civil side, so it's the Department of Law, and you're representing state agencies. And, I mean, it was anything from working at the Department of Health, where they go into nursing homes and make sure that the nursing homes aren't violating any of the regulations that are in place to protect residents. Mm-hmm. And when they are, we go after the nursing homes with penalties. So that was one thing that I did. Representing the Department of Labor, prevailing wage claims, workers that are not getting paid wages that they're required to be paid by statute. Unemployment appeals, all of that sort of thing. So, there is opportunity to do work that you feel good about. I think it was also a great opportunity as a young lawyer. In my first few years of practicing law, I was arguing in the Supreme Court. Most lawyers that start in big law firms are still carrying briefcases for the senior partners at that stage. And I've argued in the Supreme Court and the Appellate Division many times, so it was great experience.
Well, that is pretty neat.
Yeah.
And of course, you've now taken that experience and done some neat things to build on that.
Yeah.
So you mentioned the Schmidt case. So why don't we pick up with that?
Okay.
What was that case about? And
well,
what
I mean,
happened?
it started as a fairly simple case. It was a young woman who worked for a small employer and claimed that her boss sexually harassed her, forced himself on her, made comments, all that, and it caused great emotional distress. In her case, it caused her to suffer psychological injury, including an eating disorder. I mean, it was a fairly substantial claim. The reason why we ended up making law out of that case is because the jury found in her favor and it awarded her damages, but the company was a small company, and there was no real way to recover that verdict because the employer didn't have much money. And so what was interesting about that case is that we got an insurance carrier involved through the workers' compensation field, which typically is there when someone trips and falls and hurts themselves.
Right.
And we managed to convince the Supreme Court that there was a second aspect to your standard workers' compensation policy that covers harassment and discrimination. And nobody had ever thought to look there before for coverage. And it allows plaintiffs, injured employees who have the bad fortune of working for small companies, to have an opportunity to actually recover verdicts when one is awarded. So
let me see if I could. I mean, you're raising a lot of interesting
Okay.
things. Let me see if I could tease some of those interesting things out. One is, I'm interested in, perhaps the listeners and viewers are interested in distinguishing what's a case and what's not a case.
Okay.
I work in a workplace and I don't like the way I'm treated.
Right.
What distinguishes between the complaints that people might make or have and what might make a case?
Okay, and really good question. And, my phone rings a lot. And often people come in or talk to me on the phone about conduct that they're finding very troubling, that they consider harassment or discrimination. But there's sort of garden variety harassment, and then there's illegal harassment. I mean, it's not against the law if you happen to have a boss that treats you badly, if he's an equal opportunity jerk, so to speak. In other words, it's only against the law if he's treating you badly because of some protected status like age, race, gender, disability, religion. If he's treating everyone badly, then he's not treating you badly because of a protected status. He's just a jerk. He's just a bad guy. And the courts aren't going to tell employers they have to be nice. So often I have to tell prospective clients that although they've been treated badly, and although I can sympathize with how they feel, that there's no legal remedy. So there's a difference between illegal harassment and garden variety harassment.
So what happens, I guess, in the very theoretical situation where you have, a workforce that's entirely of one gender, and everyone's getting treated and mistreated in a similar
in other words,
way.
a male supervisor and all female subordinate.
So there's not,
So there's no way to distinguish. Well, I mean, you can look. I mean, harassment and discrimination is almost by definition very hard to prove. It's rare that you're going to have that smoking gun memo that says let's discriminate against the women. So you have to be able to prove it through circumstantial evidence. And what does that mean? I mean, if a male boss makes derogatory comments about women, if he hangs up inappropriate pictures in his office, scantily dressed women.
Right.
That's an indication that he's treating you badly because of your gender.
Right.
Even though there are no other men that he's treating better, because there are no men in your hypothetical situation. So there are ways to prove discrimination even when no one admits to it, but it's not easy.
Have there been cases that you've had where you thought, all right, I'm taking this case, I think it's not the strongest case, and then have been surprised by the result?
I mean, on both ways. Often you take a case thinking it's a great case, and 3 years down the line you wonder, why the heck did I take this case? Because, as the case progresses, you find out more, you get documents, you talk to other people, and suddenly what seemed like a great case wasn't such a great case. And then sometimes you take a case that you never thought was going to break new ground or result in a huge verdict. It's very hard. I mean, that's what makes my practice challenging, because, as I say, the phone rings a lot. The trick is figuring out which cases to take. Which clients are going to be sympathetic, which legal issues you're going to really be able to win with.
So how do you decide?
You go with your gut and your experience, and you try. I mean, what I often try to do is I try to do a two-step process. I often will try to take a client on initially in a pre-litigation posture where I'll try to negotiate with the former employer to get a settlement. Mm-hmm. And sometimes I'm successful and we're done, and sometimes I'm not. But in that process, I learn a lot more. I hear what the other side is, and then I have more information to decide whether I want to take it into litigation.
Right. Do you ever get any admissions during that process? Or you can't use that because it's kind of a settlement.
But I mean, you definitely get information. I mean, for example, in a harassment case, the employer might admit that the comments were made, but they might say that's not enough to constitute harassment because it wasn't, enough comments. You have to prove in the law that the comments were either extremely severe or pervasive, that they happened so frequently that they made the work environment hostile.
Right.
Yeah.
So Schmidt's one of these landmark cases, and that was I don't think of it as a case that was that long ago, but you
Yeah, that was a long time ago. That was, I can't even remember now. It was in the 90s, I think, right? Yeah, I think so.
Wow.
Yeah.
Well, we're going to be having a break soon, and I want to get into some of the other kind of landmarks, cases that you've been involved in. But we only have a couple of minutes. So before we actually, take a break, I want to make sure that, our listeners have and our viewers have a chance to know how they can reach out to you if they have any questions.
Sure.
How do they find out more about Liz Zuckerman?
Well, you can go on my website, which is www.zuckfish.com, which is ZUCKFISH. Or you can email me at ez@zuckfish.com, or you can telephone me at 609-514-0514. And we're in Princeton, and we do a lot of, contingent fee work, which means that if it's a good case and I feel that I can get results, I'm often willing to do it without much, if any, money up front from the client. Usually willing to work with people if it's the right case.
And so the contingent fee is if you're able to take it on that basis, you would only get paid if there's a recovery. If there's a recovery, and
whether it's in the negotiation process or whether it's down the road in litigation. Although litigation is a big commitment and there's costs involved, even if it's not legal fees, and so clients need to understand that.
And the litigation is when you're actually in a situation where you're fighting with the other side.
Right, where you actually file a complaint and you go through the whole process of learning about each other's case. That usually takes 2 or 3 years before you ever get in front of a jury. And and statistically, I think they say 90% of all cases end up settling before a jury reaches a verdict. So, but it's all very interesting and it's worthwhile. Yeah.
Great. Well, we're going to take a break.
Okay.
I'm with Liz Zuckerman. We're talking about employment discrimination, sexual harassment. We'll be back in a moment.
Thank you.
A person with sickle cell disease needs 15 to 25 blood transfusions a year. Become a blood donor and join a community for life. Blood donations is a generous and anonymous gift that helps save countless lives. Become a donor of distinction with the Community Blood Council of New Jersey. All blood types are needed. For those of us in the African American and Latino community, we have more type O and B blood than any other population of people. And there's a strong demand for type O and B blood. Many African Americans have rare blood types, and because of this, an African American patient with sickle cell anemia is less likely to have a reaction to blood donated from another African American. Through the Community Blood Council of New Jersey, it is vital that our blood supply reflects the diversity of our community. With your blood donation, you become a distinctive donor. Make an appointment today by calling 1-609-883-9750. That's 1-609-883-9750. Or visit us at www.givebloodnj.org. Together, we can make a difference and save lives.
Welcome back to In the Public Interest. I'm your host, Ryan Lilienthal. You're listening to us on WIMG 1300 AM, watching us on Mercer Channel 25's WZBN, and we can be found on the World Wide Web at www.wimg1300.com. Woo! And I'm here with Liz Zuckerman, a employment discrimination attorney. Her motto is addressing inequities in the workplace. She also has a very nice logo. We've been talking about some of the landmark cases
Yes.
that Liz has been involved in litigating. And we talked a little bit about sexual harassment and the case involved opening up workers' compensation to possible recovery. But you're now working on a case with Rutgers.
Which is not right. That's not a harassment case, but it is a gender discrimination case. It's an Equal Pay Act case. So it's on behalf of a Rutgers professor, a female professor, who works in the business school and who is making less money than her male counterpart. And she recently discovered that, although they've both been working in the business school for 20-plus years. And when she learned it, she was extremely upset because by all objective measures, she really outshines this male counterpart. She publishes more. Her publications are cited more often. She teaches more courses. She gets better teaching evaluations, and yet she's making substantially less money and has fewer perks as well. In other words, he has a secretary and a research assistant and a travel budget, and she doesn't have any of that. So she learned about this, and she contacted the administration very politely and said, hey, I just found this out, can we do something about it? And they stonewalled her every step of the way, and she became less and less polite about it as time went on until finally she filed first with the EEOC and then a private lawsuit, and we're in the midst of that.
And, someone might be listening to that thing. This is, who would want to work in this type of environment? Why doesn't she just pick up and leave?
Well, it's not so easy. She's been there a lot of years, and she likes what she does. She loves being a teacher. She just wants what she feels she's entitled to. And so she's using the legal remedies available to her. But it's not, unfortunately, it's what makes the law so interesting, but nothing is as black and white as one might hope. There's always gray. And the argument that Rutgers has put forward is that the reason that this male professor makes more than she does is because 20 years ago when they hired him, they thought he was the cream of the crop, a big catch, and they needed to make this terrific offer to lure him to Rutgers. And so they did that and brought him in at a very big salary, and they claim that the reason he currently makes more than she does is still a reflection of that long ago decision.
So the argument is, it's not that you're not being compensated well, it's that we made whatever decisions we made back then to him, and we probably wouldn't have made this offer to him had we met him today and known what we...
And I think what they're saying is, since the decision back then to pay him more than you wasn't based on gender, it was based on our perception, right or wrong, that he was this great guy that we just had to have. they're saying since we didn't make that initial decision because of gender, then we can't be held guilty for continuing to pay him more than you now, because if it wasn't because of gender then, it can't be because of gender now.
Yeah, and so that's one employee. Is she, in terms of what the law requires, does she now have to show that, she's not being compensated in an equal way compared to all of her?
No, she doesn't have to show that. The law under the Equal Pay Act merely requires that you find one comparator, which is someone who's of the opposite gender who is doing equal work for more pay. So they're both Professor 2, which is the highest level professor. They're both in the marketing department in the School of Business at Rutgers University. So that would be considered, her comparator. And even if there are men that make less or women that make more, she's comparing herself with this man.
Right, that's a pretty close matchup,
yeah,
right?
It's a very close match. And that's another challenging part of a law, of a case under that law, because it's not always easy to find someone who's exactly like you. It's one thing to say, I flip hamburgers at McDonald's, and so does he, and he makes more than me. That's a close match. But in other work settings, it's not always so clear. A gym teacher is not the same as a math teacher. A deputy in this area is not the same as a deputy in that area. So you really need to find someone who's doing the same work for more pay in order to be able to bring the claim.
And what do you think is going to happen with this?
It's a tough case. I mean, again, this is one of those cases where when I first saw it, I thought slam dunk. She's better than he is in all objective indications, and yet she's making less. How could we not win this case? But then you do the discovery and you find out that they brought him in under this distinguished faculty program, and whether they were right or wrong back then in their assessment of him, does that, are they allowed to rely on that decision these 20 years later? I still feel that the law should require that even if that decision wasn't gender-based back then, every year there's an opportunity for raises based on merit and based on equity. Mm-hmm. And each year, if she outshines him, the law requires, I believe, that they begin to equalize and if frankly, pay her more, but at least equal to what he's making.
So once it becomes apparent that she's kind of outpacing her colleague, would a decision that you'd want from a court basically say, by that point, she should be making the same amount as the employee?
Yeah, I think so. Or, and the question is, well, what responsibility does the employer have to sort of reassess that situation? But in this case, there were a couple of opportunities, because when she first joined Rutgers, she was in the New Brunswick school and he was in the Newark school. And 10 years later, those schools merged and became a single entity. So at that point in time, I believe the university had an obligation to make sure that there was no pay inequities. And if it didn't do it then it certainly should have done it a few years ago when my client discovered it and said, hey, take a look. So they had opportunities to say, you know what, you're right. You are now, if not then, you certainly are now as good or better. You should be paid as much or more.
And so in your case, do you look for not only change in salary going forward, but do you also go back and look for, I don't know what they call it, back pay or whatever it's called?
Unfortunately, yeah. The federal Supreme Court made a ruling recently that limits the amount of how long you can go back. So you can only go back 2 years or 3 in the case of willful violation of the law. So it doesn't allow, unfortunately, she'll never make up the 20 years or 15 years of pay inequity. But if we can get her back pay for the last 2 to 3 years and get her on a par so that for the next 10 or 15 years she's paid as she should, she will be satisfied. And the law allows for the recovery of attorney's fees, so it allows me to earn a living while making sure that she gets what she's entitled to.
Yeah, so I think of this issue, on the forefront because of the law is unsettled, but also I think of Barack Obama as a campaigner raising this issue, and somehow think that one of the first pieces of legislation that was passed by the Congress in 2009 had to do with pay inequity, and I forget the woman's name.
Right, the Lilly Ledbetter case.
The Lilly Ledbetter case.
Yeah.
Thank you.
That's right.
And so, what did that do?
I don't even ask me because I'm not so great at that. But I do know that that was the federal case that limited how far back you can go, and I think Congress addressed that case to correct a wrong that they felt had occurred in that case. Right. So that's where we are.
So, one more, cutting new path case that you're working on. There's another, a more recent case in the Schmidt case, United Rental.
Yeah, that was an interesting case, too.
What was that case?
Okay. Well, that was also a sexual harassment case. But what was interesting about that case is that my client was... Most sexual harassment cases... you have someone who claims that they lost their job because they refused to, let's say, have sex with their boss. I mean, that's one form of sexual harassment. It's called quid pro quo. If you don't have sex with me, I'll fire you, right? Well, in this case, the United Rentals case, my client claimed that she lost business. In other words, she was the president of a company that did business with another company, United Rentals. They had a contract, ongoing contracts. And the new manager of United Rentals started coming on to her. And when she rejected him, he started pulling the business away. So her company started losing business from United Rentals because she refused to have sex with the general manager. And the trial court said, sorry, that's not harassment as we understand it because she wasn't an employee. And we got that trial opinion overturned by the appellate division and affirmed by the Supreme Court to say that no, the law against discrimination in New Jersey also prohibits one company from refusing to do business with another company because of gender, and that would be included in that.
So that's an amazing thing, and a huge victory.
Yeah.
I mean, what is the provision of the New Jersey law that made that possible?
Well, I mean, it's 12L. 12L. But, I mean, what it means, for example, is like if you went to a gas station and they refused to serve you because of your ethnicity, that's refusing to do business because of a protected status. Nobody's really quite looked at that provision before. Everyone has always thought of the law against discrimination as an employment discrimination statute. But it has a broader reach, and that's what this case is starting to really look at.
Mm-hmm. And, I mean, this example that you're bringing in terms of the gas station
right.
and, another type of immutable characteristic.
Yeah.
I mean, I guess that's more I think of like Rosa Parks type of discrimination. I mean,
right.
that's with the government.
Right.
But why should this be any different?
Right. And I actually also had a case where I had a female client who was a patient in a hospital. And she was harassed by her doctor, sexually harassed by her doctor. And again, the law against discrimination, the trial court didn't understand that it applies not just to an employment setting, but to any place of public accommodation, is what it says. So if you were being harassed in any place that's open to the public, and the harassment is because of race or gender or nationality, disability, anything like that, it's a violation of the law.
So, there's so much more we can get into, and of course we've run out of time.
Okay.
But I wanted that the listeners and the viewers have another opportunity to know how they can reach out to you with questions they have, possible cases.
Sure.
How do they contact you?
Okay. You can find me on the web, www.zuckfish.com. That's ZUCKFISH.com. You can email me at ez@zuckfish.com, or you can call me at 609-514-0514.
This has been great. I've been here with Liz Zuckerman, an employment discrimination attorney. Yeah. You've been listening to WIMG 1300 AM, watching WZBN Mercer Channel 25, and on the web at www.wimg1300.com. Thank you.
Thank you, Ryan.